afternoon, everybody. I'm Rachel Stockman, and you are watching the Law and Crime Network, and we have so much stuff to get to. I have papers all over the place because we have so many different cases going on. I'm confused here. Is she recused? Is she not recused? There she is commenting about her office's decision, yet she claims to have recused herself. Now these text messages that we just were mentioning coming out saying, so I'm recused, but when people accuse of us of overcharging cases, 16 counts on a Class 4 felony becomes Exhibit A. Let's bring in my great panel this afternoon. Jason Friedman, trial attorney, joins me here on set. And Judge Ashley Willcott, you join me from Atlanta, Georgia. You've been following this case along with us on the Law and Crime Network. Let's take it to you, Ashley. What do you make of these text messages that are coming out showing that she was indeed very closely following this case, and it seems like trying to sway the outcome of what happened to Jussie Smollett?
Absolutely. To me, here's what she did. We all know as lawyers how to recuse ourselves from cases. As a judge, I hear when attorneys say I need to recuse myself, and that means they are no longer involved in the case whatsoever. I think she used the language. She said, okay, I have to recuse myself, but I do believe that she continued to try to influence the outcome. Clearly by those texts to me, Rachel, she thinks, hey, he was overcharged. This was overzealous. And you can't do both as a lawyer. You cannot say on one hand, I need to recuse myself, but on the other hand, I'm going to keep my fingers in the pie, and that's what she did.
Let's talk about this other message she sent, this text message she sent. Pedophile with 4 victims, 10 counts, washed up celeb who lied to cops, 16. On a case eligible for deferred prosecution, I think it's indicative of something we should look at more generally. Okay, so that's an interesting point she brings up, Ashley, in that, you know what? Maybe this was a case, potentially, of prosecutors gone wild, charging 16 counts on, you know, what could be considered, in the scheme of things, a rather minor violation of the law.
Or the opposite of that is perhaps the pedophile should have faced more counts, right? But I do think she makes a very valid point. We have to be very cautious. I have a judge have to be cautious that we treat everyone in the community the same in terms of if we have evidence, the state being we, has evidence to say that they need to be charged with a crime and to support all of the counts, everyone should stand equally in the eyes of the law. It shouldn't make a difference if you're rich or if you're not. And if there's discrepancies in their office with how they charge individuals based on who they are, they do need to look at that. The error she made is just focusing on this particular case versus an overall, we need to look at our whole system in this office.
I want to turn now to a defamation suit that was filed against a very well-known attorney, Alan Dershowitz. It was by a victim in the Jeffrey Epstein case. In a sworn affidavit that was filed in federal court, more information was revealed. She says she was sexually assaulted, and her then 15-year-old sister was also molested by Epstein and his companion back in 1996. So more details are coming out in this defamation suit against Alan Dershowitz. As part of this suit, this victim, Miss Maxwell, claims that Alan Dershowitz also forced her to have sex with him and other prominent wealthy men. We actually interviewed Alan Dershowitz a couple of months back about these allegations. Here's what he had to say.
The goal of going after me was to get a lot of money from Leslie Wexner, who was accused of the same thing. They accused me publicly, and then they accused Wexner privately in an attempt to get some money from him. But, and the best friend told me that Virginia Roberts told her she was, quote, she felt pressured to include me, even though she had never previously mentioned me as one of the people with whom she allegedly had relations. So my case is completely closed over. I've been completely cleared. I had nothing to do with it and never met the woman. And this is a woman who should be seriously punished for having submitted false information and a false affidavit.
All right, complete denial there from Alan Dershowitz when we first spoke to him with regards to this case. This is a defamation case that is that this woman is trying to move forward in court based on what Alan Dershowitz has said publicly. Ashley Willcott, Based on the limited information that we know so far about this case, do you think she has a shot at prevailing in this?
The only reason I think she might have a shot is because of the way in which he's responded. It's one thing to say there's no truth to it, I didn't do it. It's a very different thing to use words as you're a liar, talking about her, you've made all this up. And the words he used, not in the interview clip, but in some other sites of what he said, are very defamatory. And I think that's part of the issue, is how he's chosen to defend himself and some of the words that he's used.
All right, whether you want to see it or not, Florida prosecutors intend to release video in the Robert Kraft case. You'll remember he's facing those prostitution charges for his alleged involvement in a prostitution out of a massage parlor near Palm Beach County. We've been following this case very closely because there was a question. Defense attorneys were trying to challenge a move by the media to get this video released on constitutional grounds. They believed that it was collected illegally. So we're going to, first, before we discuss this, because it's a very interesting case, prosecutors are now saying, though, that as the custodians of the records, they cannot delay the release of the records to allow a person to raise a constitutional challenge. The Public Records Act in Florida does not allow a custodian of the records to delay the production of records to allow this resolution. So basically, the prosecutors are saying, we have no choice here. We can't withhold these videos, which may be akin to pornography, just because there's a challenge in the courts. We have a right, or a duty, I should say, under the law to release that video. And it should be released within a day or two. Well, Ms. Schulman, representing the media there, apparently did a very persuasive job, but it was actually the prosecutor's office deciding to release this video. We should probably see it in the next day or so. I want to mention the prosecutors say they would forward the video pixelated. So I assume that to mean, Jason and Ashley, that some of the more pornographic elements of this video will be blurred out. There is a possibility, Ashley, that a judge could rule that this video was illegally collected by investigators and not allow it to be admitted if Robert Kraft's case goes to trial. Do you think that's a real possibility here?
Well, I do, and I agree exactly with what Jason said. Two different standards, two different issues. So let's talk about admissibility in court. If it's deemed by the court to be found what we call a fruit of a poisonous tree and not admissible, think about this. We were talking about it on a break. If, who knows, under the ruse in which law enforcement put the cameras in this facility, they might have been videoing everybody who went in for massages, even those who went in for legitimate massages, and he did until he's convicted, and show all these individuals on videotape. So there are very real reasons why a court, a judge, if the argument is made, might find that this was gained in a way that was not legitimate and should not be admissible in court.
Because let's think of it from a practical perspective, putting legal ease aside. Can the cops just go into a public facility, right? I mean, you know, a massage parlor, it's privately owned, but the public can go and install cameras in a private area where even if the massage parlor was doing legitimate things, which they could have been doing some legitimate things, there could have been some people there that were actually getting massages, but in order to get a massage, you have to get naked. And there, the feds have installed a camera and they're surveying you. Okay, this is a fascinating case, and let me tell you, we'll be monitoring. If the tapes are released, we will show them and put them on Law&Crime very much blurred, as they are a matter of public concern and interest. But it's certainly an interesting argument, the privacy concerns, the constitutional concerns, and then the public's right to know as it relates to the open records law. So we'll continue to follow that case very closely. In the meantime, we have to take a quick break, but when we return, we'll take you inside a case in Ohio about a babysitter accused of killing the little girl she was babysitting. Stay with us.